Hi, I'm Sam Cacciatore of Nance Cacciatore, and I'd like to talk to you a little bit about health insurance liens, or the health insurance company's right of reimbursement. Many of our clients tell us that they don't want their health insurance company to have to pay their medical bills, or they don't want their insurance company of any type to pay their medical bills when someone else is responsible. They're often worried about either the fact that their rates will go up, or that an insurance company won't pay the bill because it's not their responsibility, or some other concerns. I always respond to these clients and explain to them, no, you're the one that was injured because of another person's at fault. That person is going to pay down the road, but right now your main goal is to not have to pay money out of your own pocket. Number two, it is very unlikely that the health insurance company will not be reimbursed, at least to some level down the road, when you make a recovery. The health insurance companies will most likely get their money back, or at least a portion of it, a fair portion. Now, along those lines, I would also comment to my clients that the health insurance companies, that they are in the business of taking on this loss. Whereas you, my client or potential client, is not in the business of taking on that loss, and therefore, let them do it. Let them take that loss on. Now, these health insurance plans typically have a clause that say, if you are harmed and you seek medical care because of that harm and someone else caused that harm, that they get their money back that they've paid out. For instance, you get hurt because of someone else's negligence and you go to a doctor and you pay that doctor $100, or rather that doctor is owed $100. You want that health insurance company to pay that doctor, and then at the end of the case, they will come in and say, we want our $100 back. Now, the statutory scheme upon which they can claim their money back is either federal ERISA statutes or Florida statutes. And which one applies depends on your health insurance plan. It's a pretty long topic to discuss exactly what divides the two or what plans fall under which statutes. But as a rule of thumb, it's safe to say that if your plan is through an employer and your employer is a government entity, such as the school board or the sheriff's department, then your plan is governed by Florida statutes. If you purchased your plan on the exchange or through your own agent on your own, then that would be governed by the Florida statutes. However, if you work for a large company that is self-insured, such as L3 Harris or Grumman, then your plan is probably going to be governed by the federal ERISA statutes. Let's talk about the difference between the two. It is in your best interest, or normally works out better for you, if your plan is one that falls under the Florida statutes. Under the Florida statutes, that plan is only entitled to receive back their pro rata share of the amount that they paid out that you recovered. In other words, if for some reason something goes wrong with your case and you only recover a small portion, or let's just say a percentage of the true value of your case, they are only going to be able to receive back or be reimbursed on that value, on that percentage that you did receive. Let's say that you have a case that's worth $200,000, but you receive $100,000 in return. Maybe your recovery is $100,000 because that is all the insurance coverage that there is. In that case, then that $100 bill that they have paid is going to be reimbursed to them at 50% or $50. And it's going to be further reduced because of the fact that you've paid attorney's fees and costs, and they're going to have to pick up their pro rata share of the attorney's fees and costs. So as you can see, a lawyer's job is not always done at settlement. Oftentimes, some real work, sometimes the real work, and the hard part of the case is maximizing that recovery by dealing with these health insurance carriers who have paid out on some of your medical bills. The federal statutes don't work out quite as well, although we can normally work with them. Under the federal statutes, the federal ERISA statutes, if they have the language in their plan, and they all typically do, then they are entitled to every penny that they've paid out, even if you've only recovered a fraction of the value of your case. It's not really fair, but luckily, we are normally able to deal with these insurance companies, normally, not always, and have it where they will reduce down the amount that they will accept. In other words, a lot of times they recognize that you've had to pay an attorney and you've had to pay costs, or that you had a pre-existing condition, or that maybe you had some fault that contributed to the crash, or maybe there was limited liability coverage. And they understand that in those situations, you did not recover the full value of your case. Oftentimes, we're able to work with them and have them work with us and reduce down the amount that they are owed and reduce down that right of reimbursement to an amount that is fair, so that you, the victim of the harm, are the one that actually receives the bulk of the recovery and not them, even though they are entitled to it under their plan language and the federal ERISA statutes. These can be very complex matters. I'm trying to give you a thumbnail sketch, but that is one reason that it is very important to hire a lawyer that can help you navigate this area. Because like I said, once the case is over, or once the settlement's in, the case is not over. The case is over when all these issues are resolved. Now, as I said, there are other issues that play here. Medicare is a bit different. Medicare has a set statutory formula about what they are reimbursed. Medicaid, same thing. Medicaid claims that they get everything back, but there are ways to fight that. But again, those are topics of another discussion and another day. So, in summary, if you are injured in a car wreck, trip and fall, slip and fall, or any other mechanism where someone else is at fault, allow your health insurance company to pay those bills and then let the attorney determine which laws apply and pay them back the appropriate amount. Additionally, the benefit to you is when those insurance companies do pay those bills, they also pay them at an adjusted rate or a reduced rate because of contracts typically. And in those situations, they only recover the amount they paid out. And so it is to your financial benefit to have them pay those bills, reflect the adjustments, and then allow the lawyer to pay them back out of your recovery just the pro rata amount of what they paid out on those bills. If you have any questions, I hope you will give us a call. Our number is 321-777-7777. Thank you.